All rise. The Court of Appeals, Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in Morgan versus Stuber, our cause number 1CA CV130046. Counsel, as I'm sure you're aware, we've recently begun the practice of videotaping these oral arguments, so and disseminating them on the internet, so be aware of that if you would. We have, of course, read the briefs and conferenced this case before coming into court this morning, so we're quite familiar with the issues and the facts, and you can bear that in mind as you make your presentations. Each side has 20 minutes for oral argument, and for the appellant, you have as much time for rebuttal as remains on the clock when you sit down. With that, we can begin.
Thank you, Judge Swan, Judge Johnson, Judge Thompson. Bob Schaefer for the defendant appellants. Before I turn to the merits, I need to advise the court that Morgan did reach a settlement last night with John Stieber. In our view, that doesn't affect the issues that the court needs to decide because there's still one appellant here that's raising these issues, but I'm happy to answer any questions that the court has about that.
Well, does it moot the issue of anti-deficiency protection, at least as the issues concern some recent case law concerning undeveloped parcels?
I don't think it does. And it's actually a pretty complicated question given the procedural posture of the case. So let me just try to back up and address that issue with the court.
Refresh our memory, though, is Mr. Stuber the gentleman who had one property with some construction on it, or two properties with no construction?
He's the gentleman that had one property that was partially built and one that at least...
And he's the one who settled?
That's correct.
Okay.
That's correct. So when these cases were initially filed, they were only filed against Mr. Stieber. Then there was a trustee's sale as to the Gotz's properties, and then he was sued, and then the cases were consolidated. The initial summary judgment motion that Mr. Stieber filed was on the anti-deficiency issue. Mr. Gotz's was not part of the case, or at least did not join that motion. Judge Slayton then ruled that Mr. Stieber was not entitled to anti-deficiency protection because the homes were not going to be his primary residence. In light of that ruling, I suspect, although I wasn't trial counsel, Mr. Gotz's did not move for summary judgment on anti-deficiency protection. However, after Morgan filed its summary judgment motion on the waiver statute, Mr. Gotz's counsel did avow that he intended to raise this issue, and to the extent this issue was going to be decided by the Court of Appeals, then it would be applicable to him as well. And there was a colloquy between the court and counsel for the parties at the September hearing where counsel did make that avow, and I'm happy to point that out in the record.
Well, assuming the issue with regard to Mr. Gotz's is properly before the Court of Appeals, the parcels were still completely undeveloped.
That is not a fact that was fully developed in the trial court, and actually it's not clear that it's certainly clear that the homes were not complete. It's not clear as to what steps were taken toward construction. So the argument about construction was not made as a basis to deny anti-deficiency protection in the trial court. That issue simply wasn't raised. So for that reason, under this court's cases, it wouldn't be appropriate to affirm on the basis of an argument that wasn't made in the trial court. At the very least, the court, if it reverses on the waiver issue, it ought to send the case back for further factual development on this issue. For example, we do know, because it's in the record, that in addition to, and all of these loans were both land loans and construction loans. It was one package. It was to acquire the property and to build the residences. So what we do know is that as to Stieber's lots, which there's evidence of this in the record, there were construction draws funded. And it appears that those construction draws went to fund some aspect of construction on both of his properties, not just the 208, which was partially built, but the 175. At least according to the evidence, some $50,000 was at least distributed to the promoters According to the records, it went to acquire materials. It's not known whether those materials were delivered to the site, whether they were delivered to the promoters, what the promoters did with the money. So I would just suggest that I'm aware of the Wildwood case, but I don't think that the Wildwood case is a basis to affirm summary judgment on the anti-deficiency claim for that reason. Separately, I understand that the Wildwood case was recently decided, but this case is really very different than the Wildwood case. The Wildwood case was a land loan. There was no indication at the time that the loan was taken out that certainly no guarantee that funding would be there for construction. That's different in this case. The lender expressly agreed and committed to loan money to construct residences.
You're saying that was the purpose, that was expressly the purpose of the loan?
Correct. Correct.
And so you're suggesting that there's a difference, that the law need not require someone to dig part of the foundation?
I think that's exactly right. And there are several reasons why that's.
Is this even properly before us today?
Well, I don't think it is. I don't think it is, because.
And I don't mean to interfere with your
No,
answer to
that-
Judge Johnson's question, but it doesn't sound, it sounds like you're advancing a theory that we should not be considering anti-deficiency at all.
I think that you should address the ground that Judge Slayton gave for denying anti-deficiency protection.
The waiver?
Well, no, not the waiver.
The
The primary residence argument.
Right.
Okay. Okay.
Because that's going to recur on remand. And Judge Slayton cried out for guidance from this court. I think that's why we're here. It's because he was saying, I think the statute is limited to primary residences. So if your honors don't touch that issue, it's going to go back down, and he's going to say the same thing, and we're just going to be here again.
Didn't I write an opinion that it applies to a condo that somebody owns one fractional interest in?
You did. You did. And the Pine Top case was not a primary residence case either. And in fact, if.
These are vacation places.
That's
They are,
correct.
remember?
That's correct. They are.
That's one argument.
So I guess just because we're on the topic, I'll just say with respect to the primary residence point, it is directly contrary to the Alberta case and the Pine Top, Northern Arizona Pine Top case, and really the Mid-Kansas case too, because there was no dispute there that the builder wasn't building these for himself. He was building them for someone else. That wasn't the reason the Supreme Court gave for denying anti-deficiency protection. If that were the rule, it would have been easy enough to just say these are not going to be the builder's primary residences. So let me turn then to the murky world of the waiver statute. There are, I guess, three primary arguments for why the waiver statute should not have been applied here. First, the language of the statute, it just doesn't apply to this situation. It says that defenses and objections to the sale are waived. Here we are not raising defenses and objections to the sale.
Wasn't the purpose of the statute to make sure that the person who buys at the trustee sale gets clear title, not subject to some technical issues that could arise later?
Correct. And that purpose is not undermined at all by allowing Mr. Gatzes to contest his liability for a deficiency judgment. If there were any dispute about the language of the statute, and I submit that it's not, certainly not, it doesn't clearly bar someone from raising defenses outside the context of challenging a trustee sale. But if there were any ambiguity about it, then the first fallback interpretive guide would be the strict construction rule. And the court's obligated to strictly construe the statute in favor of borrowers. And in that case, what that means in this case is that you can't construe the statute the way the trial court did, because the way the trial court construed the statute was directly antagonistic to the interest of the borrower. I think it's helpful to look at the BT case, the Sitten case, and perhaps other cases as establishing somewhat of a continuum, where if someone is directly challenging the claiming title to the property, such as attempting to unwind a trustee sale or bringing an action for quiet title, that's squarely within the language of the waiver statute. You can't do that. Beyond that, then, we have the situation in the Madison case, where someone is bringing tort claims, but a necessary predicate of those tort claims or contract claims is that the trustee sale was invalid. And I think Madison certainly held that those claims were barred. There may be somewhat of an open question. There are federal district court opinions that I can't really talk about, but they ruled differently. And in the BT Capital case, there were claims other than claims that directly challenged the trustee sale. There was a claim for breach of contract and other claims. The Supreme Court didn't rule that those claims were waived under 811C. It ruled that those claims did not state a claim, or at least the trial court had ruled that they had not stated a claim, and BT Capital had not appealed those claims. So, again, the waiver statute wasn't applied in that context. Finally, moving down the ladder.
Is it possible that this is an issue of first impression after years of the foreclosure crisis?
It's amazing, but I think it probably is. It's really an attempt to apply this waiver language outside the context of the trustee sale to a deficiency action. And not only does the language not compel that result, it would be contrary to the strict construction rule, but it also wouldn't serve, and in fact would undermine the purposes of the statute. The purpose of the statute obviously is finality, stability of trustees' deeds. We don't want people coming in later and saying, you don't own the property, I do. This doesn't threaten that interest. We're not challenging the validity of the trustee sale. We're simply raising defenses to a deficiency action. Now, those defenses in this case were not allowed to go forward in the trial court. They were cancellation of the notes, fraud. Certainly there's an interest that the legislature has in allowing someone to assert a securities fraud claim. And to force someone to bring that claim at the prior to a trustee sale really gets the cart before the horse. First of all, you don't know whether there's going to be a deficiency action filed, a deficiency judgment sought. So one would really be asking a trial judge in a context where the borrower doesn't dispute the transfer of title, but does dispute a deficiency. We're asking the trial court to decide an issue in the context where maybe there'll be a deficiency action filed, maybe there won't be, but there's really no adversarial oomph to the case, because the issue isn't whether the trustee sale should go forward. The issue is something else. So we respectfully submit that the waiver statute doesn't apply outside the context of trustee's sale. It certainly doesn't apply in the deficiency judgment context, and it would really undermine the purposes. The final point I'll just make on that issue is, what would happen if we had brought this action prior to the trustee sale and obtained an injunction? What would happen to the property? I mean, it wouldn't stay with us. It wouldn't go back to the seller. The seller's been paid for the property. I mean, the natural result is that it would have to go to the lender. So I'm not sure how that it would really gum up the works, I think, to force these claims into that context. Finally, I will just briefly address our claim for attorney's fees. I do believe that this is a case where wagon seller should apply. It's an interim order. It's a significant order. It's a discrete issue, the waiver statute. It's a separate unit, and we've been forced to incur a lot of time and a lot of fees in obtaining reversal of this interim order. Thank you.
Just one administrative question. Should we be expecting a filing with regard to Mr. Stieber that will enable us to change the caption on the case? And,
what I intend to file is a joint notice of settlement and I guess a dismissal of the appeal as to Mr. Stieber.
and that'll be forthcoming soon?
Correct.
Very good.
Good morning, and may it please the court. Before addressing the arguments raised by appellant's counsel, I did briefly want to at least address to the court the issue of our motion to dismiss, which I realize was denied by the court, but we re-urged it in our appellate brief, in our answering brief, and we are still of the mindset that the court lacks jurisdiction on this matter due to the untimely filing of appellant's notice of appeal. So I believe initially that this court should simply dismiss the appeal due to lack of jurisdiction because the appellants didn't file their notice of appeal until November 30th, which is long after the judgment was signed and long after Judge Slayton entered his October 15th written signed order correcting the original judgment. So under the mechanism provided by Rule 9A, I don't believe the court has jurisdiction in this matter. Moving on to...
There is some doubt as to what Judge Slayton intended his various post-judgment orders to mean, though, right?
I don't know that there's much doubt at all, Judge Swan. I think he was actually quite clear.
Did he say that he was trying to extend the time to appeal?
Well,
Leave aside whether he has the authority to do that directly, but if he wishes to amend a judgment to deprive it of finality, and then later enters a judgment that he intends to be final, there's at least an arguable question there, isn't there?
Well, if I understand your question correctly, Judge Swan, he did intend to extend the notice of appeal deadline. In fact, he said so explicitly, but I think even the appellant has conceded that Judge Slayton lacked authority to do that. And I don't know that Judge Slayton can somehow obtain the same effect by vacating the original judgment and then installing a corrected judgment in its place that altered the language with respect to the attorney's fees. There's certainly no authority that I'm aware of for Judge Slayton to do that. Particularly when I think the only mechanism to do that is provided for in RCAP 9A, which says that the trial court can vacate a judgment to effectively extend the appellate period when the appealing party hasn't received a notice of the final judgment. I don't think there's a dispute in this case that
Doesn't
everybody...
Rule 58G give some level of authority to the trial court, since 58G contemplates that no judgment will be final until all fee issues have been resolved?
Well, but I think the case law also tells us that you can have a final judgment with a 54B judgment, even though the attorney's fees issue is still resolved. And even the current judgment that's being appealed right now leaves the attorney's fee issues resolved. I think if the law was that you don't have an appealable judgment until attorney's fees are resolved, well, then there's no reason for any of us to be here today, because as of this morning, Judge Slayton has still not ruled on the issue of attorney's fees. So the law allows the court to break those into two separate components. And I would certainly also point out to the court that the differences between, or I should say difference between the original judgment and the corrected judgment is minuscule. The original judgment says the court's awarding attorney's fees subject to Morgan filing a fee application. The corrected judgment says the court will address the issue of attorney's fees at a later time. So neither judgment provided an enforcement or an ability to collect attorney's fees. They were really just interim statements on what the court intended to do with respect to the attorney's fees. But moving on to the other issues before the court, I'd first like to address the issue with respect to Mr. Gotsis and the protections of the anti-deficiency statute. I appreciate the fact that the current counsel for the appellants didn't become involved in this case until the appeal got off the ground, but it is unfortunately a case where we saw both Mr. Gotsis and Mr. Stuber invent facts as it suited them depending on the state of the law. And Wildwood created new law last week, but I can point the court to page 9 of the appellant's opening brief, in which it's referencing the lots purchased by Mr. Gotsis. It says, the promoters fully depleted the construction accounts for lot 35 and lot 44, but no permits were issued, no entitlements were given, and no construction was ever performed on these parcels. To date, these lots remain dirt, rocks, and trees with no construction of any kind. So in their own opening brief, the appellants concede that, at least as to Mr. Gotsis' lots, there has been no construction of any kind. So not only Gotsis failed to raise anti-deficiency protection in the court below, I don't think it's appropriate for Mr. Gotsis to appear here today and claim, well, that my concession in my opening brief that no construction had begun might not be correct, and we need to go back to the trial court to address this issue. So even if the issue of anti-deficiency is property before this court as to Mr. Gotsis, I think it's a conceded fact that no construction of any kind began on these lots, and therefore under Wildwood, the anti-deficiency statute simply does not apply as to Mr. Gotsis.
So you would contend that given the settlement, yesterday's settlement, there's the issue about whether the protection applies to only in the case of a primary residence, notwithstanding Judge Thompson's decision, is not relevant.
I agree with that completely, Judge Johnson. And I can address the primary residence argument if it would be helpful to the court, but I agree with you. It's just not before the court anymore now that Mr. Stuber settled the case as of late last night, because we're left with two parcels that by Mr. Gotsis' own admission were completely undeveloped and no construction of any kind had ever taken place.
Well, I was just asking the question. I wasn't making a point.
Yeah. Yes, Your Honor. Moving on to the waiver provision. The law tells us that when you have a statutory scheme like Arizona's deed of trust statutes, you have to view those statutes, not onesies and twosies, but you have to view them in the context of the entire statutory scheme. And in this case, we're talking about Title 33, Chapter 6.1, which governs foreclosures and deeds of trust in the state of Arizona. Under Section 807 of that scheme, the trustee's power to even notice the sale and complete the sale hinges entirely on the trustor's breach of the underlying debt instrument or deed of trust, as the case may be. So if there hasn't been a breach of the underlying debt instrument or deed of trust, the trustee doesn't even have power to go forward with the sale in the first place.
If the trustee doesn't think there's been an allegation. I mean, the trustee alleges breach, right? And
correct.
And the trustor can either sue to enjoin the sale or sit back and allow that allegation to stand and let the sale happen.
That's correct, Your Honor.
But the total circumstances of the breach are never litigated. They're never formally alleged. They're never the subject of a judicial determination. So it seems like you're reading an awful lot into that notion of breach.
Well, Your Honor, I think it's not litigated, but that's by the choice of the borrower. That is, the borrower clearly has the opportunity to file litigation in advance, or at least prior to the trustee's sale, right, or even, frankly, prior to the notice to halt the sale. I mean, in Arizona, the 90-day process starts with the notice issued by the trustee, but I think the court's probably aware that the standard deed of trust in Arizona also contains a 30-day notice provision on top of that, where the trustee issues a formal notice to the trustor, you are in breach. And I think at that point, that would even give the trustor a basis to come in to a court of competent jurisdiction and contest the trustee's power to even notice the sale, let alone complete the sale. Because the trustee's power to do what he or she is doing flows completely from the trustor's violation of either the underlying debt instrument or the deed of trust. And in this case, the violation flowed from the fact that Mr. Gotsis had violated his obligation under the underlying debt instrument. That is, he failed to repay the terms of the loan under the applicable promissory note.
But that doesn't necessarily mean that the lender did everything perfectly, right? I mean, inherent in your concept of breach, there seems to be a complete wiping of the slate from the lender's standpoint.
Well, I would agree.
Possible to have two breaches, isn't it?
You can have 3 or 4, Your Honor. That you can have multiple breaches, and I'll certainly agree that just because the trustee notices a sale doesn't necessarily mean that the lender has done everything perfectly. But what I am advancing is that if the lender hasn't done everything perfectly, and the trustor does not go to a court of competent jurisdiction and get an order enjoining the sale, then the trustor is not permitted to come in on the back end in a follow-on deficiency judgment action and make that same claim and say you cannot enforce the note even though it was already enforced at the trustee's sale.
I understand, but the statute doesn't say that. The legislature never specifically articulated the argument you're making, and it seems awfully inefficient to require proactive litigation on an emergency basis over a deficiency action that will never happen, or that may never happen in every case? I mean, wouldn't we be, it would be a full employment bill for lawyers, surely, because we'd be saying every borrower in default now has to get a lawyer and sue the lender to protect themselves, to assert defenses against a case that may never be brought. So I guess my concern is, number one, the statute doesn't say it. Number two, it seems like questionable policy. Why, what's the basis for imposing this limitation?
Yeah. If I could address the second question first, Judge Swan, I think the policy arguments advanced by Mr. Gotsis are vastly overstated. Most non-judicial foreclosures in this state are on residential properties where there's no Mueller questions or Wildwood questions, and those borrowers, they don't have any need to run to the courthouse to stop the sale because they know that they're covered under the anti-deficiency statute. The only borrowers...
Not if Judge Slayton's view is right.
Well,
I mean, what if we have a vacation home? You don't want us to address that issue, but if we have a vacation home and a deficiency action is brought by perhaps a creditor's attorney less schooled than yourself, now suddenly defenses have been waived when the borrower reasonably relied on the anti-deficiency statute. So to be prudent, the borrower would still have to sue.
In that limited circumstance, I would say yes. But again, we're talking about this atypical situation where the trust property is a vacation home that the borrower maybe did or didn't intend to occupy as their own. But those are the exceptional circumstances, vacation homes, commercial properties. But most non-judicial foreclosures in this state are residential properties that are unquestionably covered by the anti-deficiency statute. So I don't believe that the interpretation we're advancing is going to cause a mad rush on the courthouses in the state of Arizona, because for the most part, these deficiency judgment actions are the exception and not the rule, and it's by virtue of Arizona's anti-deficiency statute and the clear properties that it does, in fact, protect. Going to your first question, Judge Swan, which pertained to our broad reading of the statute, we are reading the statute in conjunction with 33807, which tells us that the sale can't go forward unless there is a valid debt instrument and it's been breached. And if the trustor feels differently, if they think that there's been some fraud or collusion on behalf of the lender, the statute imposes a duty on them to go to court and do something about it. And I believe that interpretation is also borne out by both BT Capital and the Madison case, because those are cases where the relief afforded under 33811C was much more than just the sale itself. I respectfully disagree with my colleague's interpretation of the BT Capital case, where my reading of that case is that the court held that by virtue of the third trustee sale, not only was the pending or the prior trustee sales essentially, the controversy there was wiped out, but it also mooted BT Capital's pending breach of contract claim for damages. My colleague is correct that there was a tort claim asserted in the trial court below in BT Capital, but was not appealed. The breach of contract damages, however, were still part of the appeal that went up to the Court of Appeals and then to the Supreme Court. So what BT Capital held is 33811C and this third trustee sale not only wipes out whatever happened with those two prior sales, but also your current pending appeal as it pertains to a breach of contract action. Because our interpretation of the statute is that it doesn't apply just to the sale, but necessarily the consequences that flow from the sale. And I think Madison supports an identical conclusion. Madison was a case where there was a trustee's sale. It was purchased by a third-party bidder, and Madison asserted tort claims, trespass claims against the third-party bidder. And the court said, your claims are invalid because they are premised on the invalidity of the trustee's sale.
Right, but that's not the case here.
Well, I believe it is the case here, Judge Swan, because Mr. Gotts's defenses are premised on the invalidity, or I should say unenforceability, of the promissory note. If the promissory note was unenforceable, the trustee could not have moved forward with the trustee sale to begin with. And I heard, my colleague mentioned something about a securities fraud defense. That's never been asserted here.
But the trustee sale happens, at the instance of the trustee, right? And if the trustee sale goes forward, the defenses to the sale are waived. They're not adjudicated. They're not invalidated. They're just waived. And so that a borrower could make an economically rational decision to say, I don't want this property. I can't pay for this property. I'm not going to spend the money to fight to assert these defenses. I will waive them, to use the language of the statute. But if you're going to come after me for more money, then my defenses to the note are different than my defenses to the sale, and those are not necessarily waived. Why isn't that a rational reading of what the legislature said?
Well, my view, or our view, of what the legislature intended was to, I think, ensure there was finality before the trustee's sale. That is, if the borrower had a dispute as to the validity of the underlying debt obligation, the validity of the underlying debt instrument, or the deed of trust, that 33811C imposed a duty upon the borrower to go to court and do something about it. And I would I guess, discourage the court from. I'm sorry. You had a question?
Go ahead.
I don't think this is. It's properly viewed through, the notion of a typical borrower, which is on a residential property. Those borrowers are automatically protected by the anti-deficiency statute. This interpretation is only going to affect properties that are not protected, such as commercial properties, entities which typically can make those rational business decisions of, well, do I want to go to court before the trustee's sale to try to stop it based on whatever their defenses are, fraud, in this case, a rescission, or whatever they're going to allege. And I also would like to point out, Judge Swan, that we're advancing a very narrow argument here as to what is exactly waived. It's a defense as to the enforceability of the note. We had never advanced to the trial court that a failure to enjoin the trustee's sale somehow waives anti-deficiency protection or...
But it seems like what you're saying is, having waived defenses to the sale, the borrower somehow collaterally is stopped from raising what would have been a defense to the sale to a defense to the note.
That's
when brought by a different party, the lender.
Right.
After the fact.
Well, the lender's also bringing the trustee's sale. The trustee's a mutual agent for both.
But the adverse party is going to be the buyer, not the. What you have waived by waiving defenses to the sale is your right to the property, which after the sale is going to be in the hands of some third party, not the lender.
Well, it really depends. There can be a credit bid, or it can go to a third-party purchaser.
But you're waiving your right to the property, and it seems like what you're saying is because the borrower could have raised the defense in an action to enjoin the sale, the borrower is stopped from waiving the defense in another proceeding.
It sounds like non-mutual offensive collateral estoppel without a judgment, which is the most aggressive form of collateral estoppel I've ever heard, I think. In fact, that's a type of collateral estoppel I don't think that I've ever heard of, Judge Swan. But shouldn't we be cautious in creating it?
I agree with. I think Judge Johnson has summarized our position, which is if you have a defense to enforceability, you have to raise it before the note's enforced through the trustee's sale. And I think the reason the court should interpret it that way is because of the legislature's command in 33811C. I'm not asking the court to invent this out of whole cloth, but there is a statutory provision that the legislator inserted in 2003, which is admittedly a very pro-lender provision. I don't know that the old command from the Supreme Court's case in Patton still applies anymore.
Is it pro-lender or is it pro-buyer?
Third-party buyer.
Yeah, it's
pro-sale.
I believe it's both, Your Honor, because the lender oftentimes is the buyer at a credit bid, so it protects. It goes to both the lender and a potential third-party buyer, depending if there's a credit bid or not.
Sure.
I see my time has expired. I was subject to any questions from the court.
All right, thank you very much.
Thank you.
No, you didn't.
I think I've made the points that I'd like to make, so unless the panel has any questions, I'm happy to just sit down and let us go all on our way.
Well, just one. What do you make of the argument that the opening brief really does concede that this is dirt and rocks? And
Well, the opening brief made those statements in the context of showing that there was fraud.
well, it's either true or it's not. If the
Well,
opening brief asserts that we're dealing with dirt and rocks, then under Wildwood, do we really have an anti-deficiency case here?
Yeah, I think we do, because what is construction?
It's something other than what nature has done to the earth.
Well, I think that there's evidence, not in the record, but there's evidence here that there was clearing done. I haven't talked directly to the builder, my client has, but these are issues that need to be decided on a full factual record.
And your point was, whether construction had begun was not litigated on summary judgment.
It was not litigated on summary judgment, and I think also we ought to be entitled to make the argument that in the context of this transaction, where the lender very easily could have said, listen, you're not going to have anti-deficiency protection because you are going to represent to us that you are not going to build this home for yourself. The lenders very easily can do that if they want to ensure themselves that there's a deficiency opportunity. In this particular case, the express purpose of the loan was to build a residence, and First Magnus's policy manual said you have to live in it. So under those circumstances, I would submit that we ought to be given an opportunity to argue that the Wildwood case is not applicable to this situation.
Okay. Thank you very much, counsel. At this point, the matter is under advisement. We'll await your filing as to Mr. Stieber, and we will issue a written decision in due course. We will stand in recess to allow the next case to set up. Thank you.